I got a woman.
Welcome back. You're listening to Protecting Your Family on Talk Radio 790 KABC. I'm your host, attorney Naz Barouti, joined by my co-host, Kerri, Kasem. And on the line, we got Assemblyman Mike Gatto from the 43rd District. Hi, Assemblyman. How are you?
It's great to be here on 790 KABC.
Oh, Mike, it's so good to hear you on air talking about, first of all, another bill you're introducing, and then I want to get into our bill a little bit as well.
Sounds good.
Great.
So, Assemblyman, you have just introduced Assembly Bill 139, which would create a revocable transfer on death, or TOD deed in California. What motivated you to implement such a bill and try to reduce improve the probate process and cut fees for families?
Well, as you know, that's just a fancy term for the fact that property should be or could be, under this measure, a little more easily passed upon the death of somebody in your family. Most of us who've dealt with probate and dealt with the process, we know that, a bank account, you can easily walk in and you can go to your bank and you can sign a form and just say, when I die, I want these funds to go to my child or to my wife or my husband or whatever. You can do the same thing with stocks. You can fill out in your Ameritrade or E-Trade brokerage that those stocks will go to someone when you pass away. California even allows us to do that with our cars. We just fill out the back of our registration form, and we just state who we want our car to go to when we die. And all of those methods, of course, avoid probate. They make it so that families don't have to go through that costly, time-consuming process. But there's one big asset that most middle-class families own in California that you can't pass that way, and, of course, that is your house. And because of that, there's a whole lot of people who need to get expensive trusts drafted if they want to bypass probate. And this bill would simply allow anybody in California to file a form with the county recorder saying who you want your home to go to when you die. And I think that would, and close your ears, Naz, but I'm a lawyer too, it would put a lot of lawyers out of business.
And I was thinking about that, and I think it's a great idea because on my show, I offer, my estate planning packages for a very low rate so families can afford it, because I know how attorneys sometimes can take advantage of the situation and charge ridiculous fees. But my only concern, not that that would possibly throw me out of business, but what safeguards are going to be in place to prevent situations where people are just, a piece of paper is given to them or they're coerced to sign, there's undue influence, there's incapacity. How are we going to safeguard these issues, and how are we going to protect people in California?
Sure. So the that concern was one that we had too. Elder abuse is something that I take seriously, and it's something that I've worked on a lot in my 4.5 years here. What we envision is, first of all, this procedure has been in place in 25 of the 50 states, and there have not been any reported problems that we're aware of. So many other states have offered this now for years. This was recommended to change in the law in California about a decade ago, and many states in the intervening decade have passed laws like this, and they haven't had any problems. But we imagine that the same ways that someone could attack a testamentary instrument would be in place for something like this. The same ability to overturn one of these transfers with undue influence or fraud, of course, would remain there. And we also would put in a provision in there that is done in most of California's 58 counties already, which is if a document is recorded, the first thing that recorder does is mails a copy to the person and says, hey, big flashing light, big piece of yellow or red paper, someone recorded a deed against your house, and did you really mean this to happen? So that's one protection. And then, of course, the other one would be that we could change the presumption by statute when one of these transfers occurs, within the last dying moments of someone's life. If someone does this to an elderly person, let's say above a certain age, and this type of transfer occurs, this deed is completed, in the final month or so before someone passes away. Well, yeah, that should have a different presumption than if somebody does this, at age 40 and dies at age 80.
Well, here's the thing, too. With my case and my father, he, was sick for a while. It wasn't just, he had all of his plans in order in 2007 when he was diagnosed. He put all of his plans in order. Then all of a sudden in 2011, he had something different. And at that point, he was unable to get past 2 sentences without being confused. So we had to go into court and fight over our 2007 durable power of health and, my father's wife over something she had him sign in 2011 where he was really at that point not able to sign that. So if you're looking at a month, before death, there are some people who have their, faculties and can understand that. But then, it could be 2 or 3 years where they're not understanding anything, and you can still get in, and have somebody sign something. And I guess...
Oh, absolutely.
Yeah,
I mean,
yeah.
and that's something that we want to stress and emphasize, is that if someone does not have their faculties, if someone is being taken advantage of, then of course I don't think that there would be any testamentary intent there, and there would be no proper intent to pass a property. We envision this being used by and large by families who don't necessarily want to have the expense of a trust. They're still going to need a will. They're still going to need some method for passing their property. But for their biggest investment, for most Californians, is their home. And for the lion's share of families, this will help them a great deal. Your father's case and cases that have happened, that I've heard about, that underscores that there's a lot of fraud that goes on anyway with regular wills and trusts and that's the sad thing, is there will always be a 1% of the population who does these really nasty things to seniors, and it's a real shame, and I think we need to make sure that we have all of those protections in place for all ways to pass property when someone passes away.
Yeah, I agree with you, Assemblyman Gatto. And I've talked to a lot of estate planning attorneys, and I've told them of this assembly bill that you are trying to get passed. And I guess the main concern with attorneys is that when you do create a trust and you transfer your assets into the trust, you have to actually fund it and go to the banks and fill out the form. So there's almost that one-on-one interaction where you kind of see if that person has capacity or if this is what they really want to do. And I guess the only verification process for these transfer of deeds is just to make sure that the notary is correct. What would you say to critics that say that this is just going to tie up the probate court even more with challenges of these deeds?
Well, probate courts are already quite overloaded, as you know, and we recognize that nobody wants to tie them up any further. But I would point to the experiences of all the other states that have had this in place for a number of years. As long as you put the right safeguards in place, I don't think that this becomes a huge issue. We can do statutory presumptions, of course, for those instances where someone does not have capacity. But, I mean, the reality is, if a married couple at age 45, fills out one of these transfer on death deeds for their family home, and when they turn 85 or 95, they pass away, and then this passes to their child, I don't think too many people are going to go back and say that they had incapacity. But yeah, in that small percentage of cases where somebody goes in, and has somebody sign something, at age 95, and that person passes away a couple months later, then I think there's going to be a real problem. But those issues and those challenges exist right now with wills and with trusts. And my step-grandmother, she had a will and leaving certain of her property, to her relatives, and then someone came along and got her to sign something that she didn't understand, leaving all of her property to that someone. And then a third person came along and was able to convince her yet again to sign something to then, completely not leave anything to the person who, ironically enough, had messed with her in the first place. And, this type of thing happens quite a bit, and it's a shame. But I don't think this is subject to any of the same concerns that any other testamentary instruments are already subject to right now.
We're talking with Assemblyman Mike Gatto. I'm Kerri Kasem. I'm here with Barouti. And, AB 139, which we've been talking about, sounds straightforward. This brings me to another point. We've been trying to get for the last year AB 2034. I'm like looking at different numbers. 2034, which I've dubbed the visitation bill, which you've authored, which just allows a judge to rule on visitation. And I thought that was fairly simple. But then when you get into authoring a bill, it really takes a life of its own. And there's, it seems simple, but then you say, wait a second. What about this? What about that? What's happening here? That you come up with opposition. I wanted to talk a little bit about what's going on with the visitation bill and where you think it's heading this year.
Sure. So for those people listening who might not be familiar with this, a lot of people, your family's case last year, Kerri, this was something that, really, it motivated some people I know to tears. There were a lot of people watching it very closely and seeing what you went through, where you just wanted to see your dad. I mean, that is a human emotion that I think just about everybody understands out there. And might I say, what your stepmother put you through was really, really horrific, and I think a lot of hearts went out to you. And you talking about this and you being willing to go out there and tweet about it and go on TV shows and talk about your experiences, thousands of other people came out of the woodwork and said, the same thing is going on in my family. My father's new wife or my mother's new husband will not let me see my parents. And, we got thousands of people writing letters and sending emails about this. And so we decided to introduce legislation that would put in place a faster, less expensive mechanism to allow the adult children of parents who were nearing the end of life to get in there and see their parents. And you're right, it was a very, very tough battle. I mean, sometimes the most simple ideas, the legislature never ceases to amaze me either, where sometimes the most simple ideas can be turned into these very complex things where there's so many people fighting it on each side.
And let me say, we had no opposition up until the final vote, basically. I mean, we went through the assembly, three assembly votes unanimously, 2 Senate votes unanimously until it got to the third and the floor. And all of a sudden, somebody's got to change something that brings up opposition. It's, I'm just learning and I'm just figuring out politics.
No, and it's frustrating. I mean, it's very frustrating.
It is. It's very frustrating.
You take a bill like this where I think most people would agree it comes from a very pure place, and people, at its core, it's just trying to provide a way to allow people to see their parents. And it's frustrating that politics comes into play sometimes, and and concerns that might not be valid. And sometimes people ask you to change a bill, in such a way that it will doom their own bill.
Yeah,
and
that's right.
So we're going to try again this year. We think this is a very important issue. We want to make sure that there is a way, absent the expense of a conservatorship, for children to see their parents, particularly in the last days of that parent's time on Earth. And we're going to try again this year, and we're going to hope that we have better luck.
I applaud you, Assemblyman Mike Gatto, because I know this isn't, an easy task, and I hope you can get more estate planning attorneys behind you to implement Assembly Bill 139. And if we can be a voice for you, you are more than welcome to come on Protecting Your Family anytime you want.
We greatly appreciate that, Naz. I mean, there's a lot of lawyers out there, I think, who are like you, who realize that the cost of doing estate planning is so expensive, and the services you provide for families are so important. And it's always good to talk to another fellow honest lawyer who, tells it like it is, and tells families that, most of the practitioners in this field, some of the practitioners in this field, they're too expensive, and there's much better ways, I think, to pass on the wealth that we've acquired. And so I applaud you for all that you've done.
Thank you so much. So if you're just tuning in, we just talked to Assemblyman Mike Gatto. This is Protecting Your Family on Talk Radio 790 KABC. When we come back, we're going to give you some tips on how you can prepare a will. This is Talk Radio 790 KABC. We'll be right back. I got a woman way over town.